Hello, everyone. I'm Jay Lazega. Welcome to this session installment of L&J's Morning Break. Today's session is going to be on lessons from the Surfside tragedy, horrible situation. We'll get to that in a minute. We're with Rob Stein and Jamie Lyons today. Hello, my friends. We're really happy to be back. We're happy that life seems to be getting back to normal, and we've gotten to see some of you. Hopefully we'll see more of you soon. But a lot has been going on. We obviously had a horrible, horrible tragedy down in Miami Beach, Surfside, where I actually grew up, very, very close to there. We're going to talk about the lessons from that and what it means to us, and there absolutely are some. And one of them, that if there's no other takeaway, is that it should be clear to everybody that we are absolutely under a much higher level of scrutiny now, and we probably will be for a long time, about our maintenance and reserve funding and operations practices. So Jamie and Rob are going to talk about that. A couple of quick administrative things. You guys have done this before. On your menu bar, there's a question tab or a question mark if you're on your phone. We'd love to hear from you, questions, comments. We will try to answer questions, but if we don't get to them, sorry, we'll try to reach out to you afterwards. We also would love to hear through the questions topics you'd like for us to cover in these sessions. We try to tailor these to things going on in the world and what you need. So send us your comments, send us your questions, send us your hellos. We love hearing that. The 5 favorites among all of those that we get today are going to get one of our brand new, very soft Lazega Johanson t-shirts. We're excited about that. Woo-hoo. So we'll pick from among the questions and comments and suggestions. Okay, also want to remind people, visit the resources section on our website, ljlaw.com, resources, tons of forms, samples, articles, blogs, quick facts, things you can share with your board on operations. And we'd love to hear ideas on additional ones you'd like us to write about. Okay, without further ado, Jamie and Rob, thank you guys for joining us.
Sure. Obviously, Jay already mentioned this, but as individuals and as an industry, we're devastated by this tragic building collapse. And this experience has touched so many lives, and there's really nothing that could ever be fixed or remedied to change this situation. But after all of this, one of the concerns that I have just in general is we are going to continue and always to need board members. And while Jay said that we're going to be under heightened scrutiny, and especially the board of directors in evaluating maintenance and repair and reserve fund issues, we will constantly, and we have always been, in need of board members. And this is going to make it harder. People are going to be more afraid to step up if they're going to get in trouble for trying to do the right thing while they're on the board. And there is nothing that I have heard so far about anything that has been put out in the press that indicates to me in any way, shape, or form that the board members were necessarily or automatically doing the wrong thing. And I just want to say out loud that we have to keep that in mind, because we have to have people step up to help us lead in these communities, and we have enough trouble as it is right now. So hopefully this will not chill it even more. But I just want to kind of keep in the back of our mind when we're dealing with all these lessons and how to move forward and for the future, that ultimately we can only move forward in the future if we have members on the board of directors to serve. So we have to encourage that as well.
And, you know, and that said, this morning's morning break session is not looking to assign blame or even evaluate what potential liability there is associated with the Surfside building collapse. Instead, what we're going to do is focus on how to plan so we can avoid that type of situation here. And as with all our morning breaks, our discussion is not meant to be specific legal advice to any particular community association. Today's focus is to discuss the challenges that many communities face as to the need of repairs, the pitfalls of not acting, strategies to move forward, and ways to avoid significant and potentially catastrophic events. We're also going to discuss the need for preparing for life-threatening and property-damaging events and disasters that can come. So we've got a bunch to cover in the remainder of our 15 minutes.
Yeah. All right. So how many of you have heard we don't want our assessments to go up? We don't want to save for future repairs. We want the people who are living in the property at the time to have to pay for it. We don't want to pay for what they have to end up repairing in 10 years from now. I might not even live here. Or, you know, if the board puts this up for a special assessment, none of us are going to be able to sell our units. Or if the board puts up a special assessment, I'm not going to pay it, and we're going to try and remove the board members because they shouldn't be charging us this much. These are all very, very standard comments that we hear from community associations when they're in the midst of trying to figure out how to fund their needs. And their needs include a whole lot more than just their basic everyday day-to-day operations. You know, if you live in a typical subdivision like I do, you know, you can ignore the leak in your garage. I mean, I can ignore the rotting retaining wall that I might have because it's only going to affect me if something goes wrong. But in a condominium or sort of a shared, you know, unit kind of setting, you can't do that. If there's a failure in the building, it relates to all of the people in the building. It doesn't relate to just one property owner. So with attached housing, you know, that is where a community is responsible for the repairs of common elements and more, the board has got to act in the best interest of the association, even if it means putting the needs of the community ahead of the needs of the individual. You know, obviously, when something goes wrong, the board of directors is going to be looking at a whole host of lawsuits potentially. And, you know, as we're going to see in Surfside, I'm sure there's going to be just years of litigation and settlement negotiations. But kind of the things that come to mind when I think about the main points of liability, when a plaintiff lawyer is going to sue someone for something going wrong, one of the first things that's going to come up is the breach of fiduciary duty. And, you know, the board of directors, the managers, well, mostly the board of directors can be sued for not making good financial decisions on behalf of the association. And, you know, we question, is not having enough reserves or not having reserves at all a good financial choice? Rob is going to talk a little bit more about that later. Breach of duty of care. You know, luckily in Georgia, the law changed as of July 1 of 2020, about a year ago. Now there is a presumption that the process that a director follows or the directors follow when they are making a decision is automatically considered in good faith and exercising ordinary care that a like person in a standard in the same situation would also exercise. And there is a presumption that there is good faith on behalf of the board, but that presumption can be rebutted by gross negligence, by showing gross negligence, and that's a really high standard. So right now, as of the end of, you know, the beginning of July of 2020, the board of directors has a little bit of cushion comparatively, compared to what it was before. And then we had Surfside. And as Jay said, that heightened scrutiny is going to probably throw that a little bit out of whack. But at least we have some statutory language now that we can hold on to. Another claim that's going to come up probably is breach of contract. You know, not maintaining the building in accordance with the declaration being a contract. I'm sure there'll be construction defect claims. There'll be third-party claims from survivors, from the estates of the deceased. We were talking about this in the office yesterday, and Jacob brought up the fact that workers who were on the pile, you know, trying to find people could bring potential workers' comp claims, you know, against the association for being injured, you know, during the recovery work. There are so many different options here. So we need to kind of focus a little bit more on what the board can do, and the best thing to do to avoid liability is to comply with the duty of care that I mentioned earlier, and to comply with your fiduciary duty, which essentially could mean doing everything possible to pass a special assessment, to inform the owners, to collect the special assessment, then to get the work done. If all of that doesn't happen timely enough, as is the problem with Surfside, there's nothing that you can do about it necessarily. But it doesn't mean that the board didn't exercise good faith. It doesn't mean the board wasn't complying with their duty of their fiduciary duty. They may have done all the different pieces they needed to do, but still a tragedy might have happened. And obviously in Surfside it did. So I think at least one of the lessons we can learn from this, and one of the things we can bring to the association, is if you have board members, if you have owners who are sort of refusing to move forward, funding issues and passing a special assessment, or looking for a loan, Surfside is the wake-up call, that gives these board members and the owners in the community kind of the push that they might need to get that job done.
At Surfside, from what I read, they had a great, 2018, it came up that they had a great deal of work that needed to be done. And they had about $800,000 in the bank and about $16 million of work that needed to be done. And, that situation, on whatever scale it is for communities here, arises. And communities have to make intelligent, knowledgeable, involved choices to be prepared to do maintenance that needs to be done. Is that doing reserves? Well, Georgia is one of 39 states that has no requirements for condominium associations to have reserves. That doesn't mean you shouldn't have them and that it's not a best practice to have them, but there's no state law requirement for them. After Surfside, we have to step back as communities and decide what is it that we're working towards. Are we going to have reserves so we have the money in the bank? Are we going to do a special assessment at the time when repair needs arise? Are we going to try to do a bank loan? Well, again, what we saw, or at least it seems like we're seeing at Surfside, is there's been pushback on special assessments, and we see that here. And bank loans, we've been in a favorable environment for the most part for bank loans, but will we be when repairs are needed to be done? I think there's a great sense that doing reserves and reserve funding is the better way to be prepared, but each community's got to make that decision on an intelligent basis. And in making that, you need a reserve study. If your boards are not doing them or haven't updated them in recent years, that needs to be done, because there needs to be a picture of what work needs to be done, on what time basis it needs to be done, and the funding that's needed to do it. I mean, that's what we all know is a reserve study that gives us the pathway, the roadmap to the future, and the protection, frankly, that we're doing the due diligence we need to do to avoid hopefully avoid the possible, some disaster situation and claims that may arise from it.
I mean, to piggyback on Rob's comments about the reserve study only talks about or addresses anticipated repairs and replacements. Obviously, it looked like that was anticipated in Surfside as well, but we also have to recognize that there may be structural and other significant elements of the building that don't show signs of need at a particular time during the reserve study, but that will later need to be reviewed. Let's talk about the work itself. When the work, you've got the money, you're getting the work done, and you are not have any specialized knowledge in engineering or construction work. When we're dealing with that kind of situation, one of the other pieces of to exercise ordinary care is to make sure that the work is being done correctly. And depending upon the scope of work and whatever the project is, you might need to be hiring an engineer or a contractor who is not part of the company completing the actual work, to supervise the work, to make sure and to review that the work is being done correctly and to industry standards. If the board doesn't have any specialized knowledge or anyone on the board who can act in that way, it might be the smartest choice to hire out a third-party professional to sort of look over the shoulder of whoever is actually completing the work. So we're talking about, deeper dives into potentially what the systems are and what the building structure looks like that may not have been reviewed before. Things that we don't necessarily expect to ever go wrong. We might need that more detailed evaluation from an engineer at this point. That also means not only might you need a deeper dive from a more specific engineer, but you also might need people to oversee the work that's being done as it's going. And that means you're paying more people, which means you're putting more money into the budget to address these types of issues. So, the idea here is that the work cannot be deferred. The board cannot hope that everything's okay, but not know that everything is okay. We need to spend the time, the money, the resources right now, especially in light of what just happened in Florida, to evaluate this stuff. And if there are defects or damages that are potentially threatening, danger, like life-threatening dangers, this stuff has to be disclosed to the owners. One of the things that I've seen, Rob talked about the stuff that's coming out in Surfside as far as the news is concerned. As far as I can tell, the board of directors disclosed all this information to the owners. There was not a whole lot of hiding of any of this information. It was all out there in the open. If there is some issue regarding health, safety, and welfare in the building, it is imperative that the board disclose that information to the owners. The board does not want to have what's called superior knowledge. They don't want information that they haven't disclosed to the owners. They want to make sure that they do disclose. And while disclosure could suck for resale values and make it more difficult to sell your property and potentially impact property values in the building, it is way more important that the owners know if there's a health, safety, and welfare issue than that they not know. Of course, if something is a deferred maintenance item that is not, life-threatening, you're not required to disclose anything, but you really as a board do not want superior knowledge about information that could impact the safety and welfare of the owners.
And another element, thank you, Jamie, another element of being prepared for whatever may arise, because it could be a fire, it could be a tornado, a lot of different situations arise in disaster planning, is to have the right insurance in place. For condominiums, that's dictated by the Georgia Condominium Act. Fire and extended coverage insurance, which covers a host of perils, having commercial general liability coverage as well. Going back to fire and extended coverage, one of the things that it covers is collapse, but there are exclusions and limitations in most policies as to how and when collapse is covered and in what sequence of events are required for it to be covered. So as always, turn to your insurance professional to determine, is there sufficient replacement cost insurance? Do we have the right coverages? Do we cover for all the events? Do we need riders to our coverage to expand our coverage to cover situations that we now see as ones that we're concerned about? Also, we of course want to have directors and officers liability insurance. Again, while not required under the Condominium Act, it's critical to defend the board for if they're sued for breaching their duties. So, in addition, with kind of bringing things towards closing to this morning and proactively preparing for disasters, we need fire and evacuation plans. We need to make sure we're testing our fire equipment. We need tornado planning. We need intruder planning. All this requires consultation with fire and police. Communication of the plans to our members and occupants of the building is critical. And practicing for those eventual emergencies, which can happen, is important as well.
Yeah, there's just so much information. We are actually, because there is so much information, as we were compiling everything, we realized that we really need to spend a little bit more time on this. And there are a lot more sort of bigger, stronger, deeper lessons that we need to go into. We're having a class that we're going to be teaching on August 19th, which is going to be a 3-hour CE class for people who have need continuing education credits. And it's probably going to be in person, although it might be still webinar, we'll see, depending on how many people we have that want to join us. And the class will cover way more detailed information about insurance, about funding, about reserve funds and financing, all these types of things, going into a much deeper dive. So we really appreciate you guys joining us today. I know that Jay's been
and Rob, sorry. Thank you, Jamie and Rob. That was great. Awesome. So here's what scares me in all of this, among many other things, and that's the new statute may help this, the current board of directors, if you're doing what you can to try to fund what are expense needs for, what may have been years and years of prior board's conduct, not properly funding, not tackling the big projects. So you may meet your duty of care under this new statute, where you only breach it if you basically commit gross negligence. That's huge for us. That's great. But it doesn't eliminate the breach of duty of prior boards, which is our corporate liability. Doesn't mean our association is not going to be liable for the 20 years of deferred maintenance, even if current board comes in and is amazing, passes a $15 million special assessment like they did down there, and starts engaging engineers and contractors. That's really scary, because as a potential board member, it's intimidating. It's certainly discouraging for people getting involved in communities. But on the other hand, we have to be involved. It's our property. Usually, it's our greatest assets for most of us. So we will see how this plays out over the next few years. But Jamie and Rob are right that absolutely the key is we can't make guesses. We can't wait. We can't defer. We can't rely on we don't have money. Our job is to get the money, however it has to happen. And if that means convincing members to approve special assessments, budget increases, we have to do that. If it means going to courts to do that, we have to do that. And disclose. Jamie talked about disclosure. Disclosure is huge. We have to let the community know the status of condition of our property. But I'm a big believer in you can't hide the message, but if the message includes the positive of what we are trying to do to address it, everybody will receive it in the right way.
Absolutely.
So that's the answer, is deliver the message, but explain what we're doing about it. Okay, thank you for joining us. We miss you guys so much. Hopefully we'll see you soon. Take care, everybody.